Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Wednesday, April 23rd, 2025. In this week's episode, a teen is accused of murder for throwing a stone through a woman's windshield, causing her horrific death. Plus, jurors reach a verdict in the case of doomsday mom Lori Vallow Daybell, facing charges for the death of her fourth husband. But first, opening statements in Karen Reed's highly anticipated retrial as jurors get their first look at prosecutors' second case against the woman. Today, we are joined by Tara Malek, a litigator, entrepreneur, and legal analyst you can catch on outlets across the country. Tara, welcome.
Thank you, Josh. I'm very excited to be here with you.
We were talking a little bit beforehand. You and I have both been on panels on other channels and discussion groups before, and I had always thought how bright you are, and I looked forward to one day having you on True Crime News. So thank you again for carving out the time. And I know you've been following these cases closely. So let's just jump into the first one here out of Dedham, Massachusetts. After one hung jury and a barrage of hearings, Karen Reed's retrial is underway with prosecutors pivoting in hopes of gaining a conviction. Reed's high-profile case has been the subject of controversy both locally and nationally since the woman was charged with hitting her police officer boyfriend, John O'Keefe, with her SUV back in 2022. Reed's defense maintains the woman's innocence, alleging that the death was part of a cover-up and criticizing the flawed police investigation in the wake of O'Keefe's death. While Reed's defense will be presenting a similar case to the first trial, Special Prosecutor Hank Brennan indicated in his opening statements that Reed's own public statements will take a prominent role against her this time around. This could be problematic for Reed given her prolific media exposure. Brennan began his opening describing the scene where O'Keefe was found in a near blizzard conditions and Reed's alleged refrain to first responders, "I hit him, I hit him." The attorney also shared a clip of Reed from an interview where she appears to question her own innocence, saying, quote, "I mean, I didn't think I hit him, but could I have clipped him?" However, Reed's defense maintained that the man didn't die from being hit by a vehicle at all when Alan Jackson delivered his opening statements on the woman's behalf. Though some limitations have been placed on the defense's, quote, alternate suspect, theories, a key in their argument will be the abhorrent conduct of State Trooper Michael Proctor, a lead investigator in the case. While the case's presentation has seen some changes, it remains to be seen if the jury will reach a consensus this time around, and we will, of course, continue to keep you updated. Tara, first thing on this, and to me, this probably will be, if anything, something that will have a different impact on this case. I feel like if we look back later and there's a different result, we're going to point to this. And that is this revised approach by prosecutors with presenting her statements to the media since the time that she's been arrested. She's done several interviews before the first trial and several interviews since the time of the first trial before the second trial, including a nearly all access documentary. And they plan on using a lot of those statements. What impact do you think those might have on the jury?
I think they're going to have a pretty monumental impact. And I really agree with you, Josh. I think that, those statements don't make her look particularly good. And they highlight some inconsistencies in the positions that she's taken, the statements that she's made before. And I think that's going to be very problematic for her. Now, while the defense may spin that and say she's trying to, and I think they have to an extent, try to explain away some of her comments and say this is a woman who is trying to grieve and make sense of the occurrences and was questioning it, wasn't actually making definitive statements that she did in fact hit him or didn't hit him. I think at the end of the day, when you look at the entirety of the circumstances here and what we already know the state is going to be presenting, in addition to these statements from her, inconsistent statements from her, it's not going to look good. And it really is going to get this jury to question, I think, her credibility.
I agree with you. I listen, I think defense attorneys, it seems like first job is always just keep your client quiet. Usually it's please don't talk to the police. We don't know how they might use that against you. But then when you've got a client who just kind of insists on continuing to talk to the media, I've never really seen an instance like this before that isn't involving a celebrity. And this is not so much a legal question, but just kind of what do you, as a potential juror, how do you think it might rub them knowing that a lot of these pieces of video they're going to be shown are from all sorts of, Dateline and 2020 and, documentaries that they've done? Do you think there might be some sort of collateral effect from the fact that she's just been so willing to give interviews about a case involving the death of her boyfriend?
Yeah, I think they're going to be hypercritical of that. These jurors are just like you and I and your audience here, and they're going to be using their life experience when they're evaluating and weighing out the information that's being presented to them from both sides. And if they get the impression that this is someone who goes out and is seeking celebrity and is seeking attention and the spotlight, and then you add it on to now she's making these statements which are inconsistent with other statements that she's made previously, it doesn't look great. And I think you're exactly right. As an attorney, and when you have a client who's out there who's under scrutiny, the last thing you want them to do is go out and make a bunch of statements and do a bunch of interviews. You usually say, just sit tight, be quiet. I'm going to handle this and we'll do it the right way. And I think there is blowback, and I think you're spot on. This could really go poorly for her. And in a case that has been so close before, and where there has been a hung jury before, you really don't want to do anything that would jeopardize the defense. And this would seem to me strategically to be not the wisest decision.
Yeah, that's the thing about it, is that these interviews are not like, maybe some of them that they're going to use are, but, it's not like, oh, this is an interview of her shortly after the arrest or her leaving the courthouse or something. These are like sit down interviews, lighting, hair and makeup all done. These are full productions, and that's pretty obvious from the clips being used. To your point, I think they might, even though no one's talking about it, they might infer, well, was this lady trying to seek some sort of celebrity status out of this whole thing? And that might just rub them the wrong way. But another thing about these media clips is nowhere in there is she going to say something like, well, I really wanted him dead that night. I mean, nowhere in there is there going to be a full-fledged confession. And to me, and I'm curious to hear your thoughts, the state still has a really heavy lift with trying to argue second-degree murder here and the intent involved in all of that. And I'm curious to hear your thoughts on that. Are they overreaching with these charges?
I don't think that they're overreaching with charges. I think that, the cases that end up going to trial are the cases where there is a kind of a question mark. It could go a little bit of both ways. Otherwise, if it's a slam dunk case, why would anybody go to trial? They would take a plea deal and try and get the advantage that they have and get some concessions on the other end. I think that the state is probably acutely aware of their weak points, their Achilles heels, if you will, having gone through this once before. I think the introduction of a new attorney is going to be very helpful. I think that the defense, to your point, before, it hasn't done themselves any service by going out into the community, into the world, and making these very public statements. I think it has also allowed the state to probably tighten their theories of the case and allow them some additional time to really evaluate the narrative or the story that they're telling through these different pieces of evidence. So It's never fun to go after a mistrial and to try a case again. Unfortunately, I've had to do that before. Memories don't get better over time. They fade. And I think the state is going to have to deal with that with some of their witnesses, but that's the same thing for the defense. If the defense puts on witnesses, this go around again. And so, those risks increase, and you have transcripts of prior testimony under oath. So, the other risk for both sides, and I think it's equal for both sides, is if someone is going to testify different than how they testified the last time to a particular question. Most of us don't go back and, read transcripts or recordings of things that we said months ago or a year ago. And certainly these witnesses are going to be prepared by the attorneys, but that's always a risk as well. If they misstate something and it's in contradiction to what they said before, I think both sides really are going to have a difficult time clawing their way back from that and regaining credibility of this witness for the jury.
You're 100% right on that. I mean, they've got statements, some of these witnesses, statements they made to police, perhaps first responders, then statements they made to investigators, then statements they made to the grand jury, then statements they made during the first trial. And now they're testifying, some of them, to these events for the fifth time around in this trial. And you're right, in the hands of a skilled defense attorney and cross-examination practitioner, they're going to have a field day. And any little misstep, misquote, change in their testimony doesn't just become, oh, well, I'm phrasing it differently now. It's, well, were you lying then or are you lying now? And I feel like that's exactly what a lot of the cross-examination is going to turn into. One last point on this case. One big outlier here is the fact that the lead investigator, State Trooper Michael Proctor, was, first of all, ripped to shreds the first time around because of these text messages that he had sent to friends where he made very derogatory statements about Karen Read. He has since been not only suspended and disciplined, but fired by the law enforcement agency that he worked for. And yet he will still play a central role in this go around. And we know that because of the opening statements from the defense, where they talked again and again and again about Michael Proctor and what a bad guy he is. How does the prosecution handle that? Is there any recovering from the idea that your lead investigator was fired, terminated, and it was in relation to the work that he did on this case?
It's so hard. It's so hard. I think that, the conduct doesn't help the prosecution at all, because whenever there's conflicting information through different witnesses or conflicting theory of the case, what do we all look at? Well, who's more believable? Who's more credible here? And when you have someone whose bad conduct or conduct was so egregious and so bad that they were ultimately terminated, and we know they made inappropriate statements about, the case or the individual who's now up for trial, it starts to color how you accept and how you process their testimony, right? They might you start thinking, well, maybe they have a bias against this person. Maybe it was a frame-up job, which is how the defense has portrayed this before. Was there just a dislike of her and that she was targeted? Is he going to embellish his testimony just to kind of save face? So I think the prosecution is going to have some difficulty here for sure with this witness. And, the case obviously that we've all heard of that brings it to mind, where a lead investigator has some really terrible information that comes out at trial against them, would be the O.J. Simpson, Mark Berman situation, right? I mean, that's the classic example that we as attorneys, our mind will go back to, just because it was so prevalent and it was so studied, that case. And I think there was a new documentary that came out with the last couple of years too. But same sort of situation where the prosecution is grappling with, our star witness or one of our main witnesses has this bad fact or these bad facts and instances that are going to be brought up. how do you deal with that? One of the tactics, as you know, Josh, really well, is that you draw the sting, right? You come out first and say, as the state, you say, okay, you're going to hear testimony from this person, and you're also going to hear that they were ultimately terminated for inappropriate comments and things that they've made. However, that doesn't change their, testimony about X, Y, and Z, and here's why. So you get ahead and provide that explanation before the defense can present it to the jury as a gotcha. Well, they didn't tell you that this guy, was ultimately fired because of these comments. So that's one of the best tactics and ways to do it.
Yeah. Yes. I thought the same thing. I thought you got to steal their thunder. You don't let them recreate this moment that they had in the first trial and double down on it in the second trial by having this, just wait, folks. The lead investigator is so bad. And, this kind of fire and brimstone sort of a moment. But Hank Brennan didn't do that, interestingly enough. In fact, he didn't even mention Michael Proctor in his opening statements. And with that, Alan Jackson gave his opening. Oh boy, did he take advantage of that by even saying one person's name you did not hear was Michael Proctor. And let me tell you why. So already they're making hay with it. We will see how this whole thing turns out. It's kind of a fascinating case to watch.
You know how you see those posts all over social media that if you didn't stop to get that coffee every day going into work, by the end of the year, you would have saved, $1,000, $2,000, unless, of course, you do 6 shots in your coffee beverage. Anyway, that really got me thinking about how just a little bit of money saved every day can really result in huge savings. And that brings us to today's sponsor, Acorns. April is Financial Literacy Month. That's right. They made a whole month reminding you to finally take control of your money. Good news is you don't need 30 days. Acorns makes it easy to start saving and investing for your future in just 5 minutes. You don't need to be an expert. Acorns will recommend a diversified portfolio that matches you and your money goals. You don't need to be rich. Acorns lets you get started with the spare money that you've got right now, even if all you've got is spare change, like from the coffee. I know investing can be confusing at times. There's no one way to do it, and there's no rule book that you must follow. That's one of the reasons I like Acorns. It makes investing simple. Sign up now and join the over 14 million all-time customers who have already saved and invested over $25 billion with Acorns. Head to acorns.com/truecrime or download the Acorns app to get started. Paid non-client endorsement compensation provides incentive to positively promote Acorns. Tier 1 compensation provided. Investing involves risk. Acorns Advisors, LLC, an SEC registered investment advisor. View important disclosures at acorns.com/truecrime.
But we're going to have to leave it there for now and move on to Phoenix, Arizona, where doomsday mom, Lori Vallow Daybell, has been convicted in her 4th husband's death, months after she and her 5th husband were convicted for the murder of her children. Prosecutors argued that Vallow Daybell enlisted the help of her brother Alex Cox to kill her estranged husband Charles Vallow to cash in on a life insurance policy and move on to her marriage with Chad Daybell. Vallow Daybell attempted to defend herself at trial and told jurors that the death was self-defense, with Cox shooting Vallow in a confrontation after Vallow hit him with a bat. In their dramatic closing, prosecutors showed jurors a 90-minute presentation laying out Vallow Daybell's motives: financial, romantic, and religious. Meanwhile, Vallow Daybell wrapped up her closing in around 20 minutes as she told the jury that the state failed to meet their burden and classified Vallow's death as a family tragedy. However, jurors ultimately didn't buy Vallow Daybell's account of the fatal incident. While the conviction could grant Vallow Daybell another life sentence on top of the 3 terms she's already serving in Idaho, sentencing will be delayed until she faces trial for yet another murder plot, this time involving the attempted killing of her niece's ex-husband. It just never ends with this woman. I'm curious, Tara, I've asked a few attorneys this. How do you think Vallow Daybell did as a pro per, or what they call pro se defendant in this case?
Well, I think that she struggled, which I'm not, I don't think anyone is surprised at. It can go both ways with a pro se defendant. And I've certainly seen it where a pro se defendant is supposed to be treated the same as someone who is represented. So the court can't give advice to someone who's not represented. The judges are usually more cautious about making sure that, the process is followed to a T. But sometimes, especially with a jury, if they think that there's some viable defense, they will give some latitude and grace and some leeway to a pro se defendant. I don't think that happened here. I think that Vallow's presentation was, in certain instances, illogical. It was contrary to physical evidence that had been presented. I don't think that she necessarily did an effective job on cross-examination. And her defense here was a self-defense, that this was a killing that had to happen because of self-defense. And she had argued it was self-defense, that she deserved the right of self-defense, that her brother deserved the right of self-defense, and that her daughter, who is deceased, deserved the right of self-defense as well. And, when you're putting on that type of defense, even though you don't have to put on a defense at all as a defendant, the burden is on the state. You would want to. I mean, this would be a situation where you would want to bring other people in to describe, the violent tendencies or nature of this person that would have led to such a situation. I think it was an error not to do that. And had she had legal representation, that may have been something that did come out. We'll never know. So I obviously from the result, it was an ineffective position to take. And we'll see what the rest of this looks like for our next case.
Yeah, you make such a good point about self-defense cases being kind of unique in that they almost require some sort of evidence being presented by the defendant rather than just hoping your case is worked out through cross-examination. But as you were speaking, and I'm curious to hear your thoughts on this, I almost feel like her abilities as representing herself were almost right in that sweet spot where she was just competent enough that she didn't gain the sympathy of the jurors. In other words, sometimes a pro per or pro se defendant can be just so bad that there's a sympathy element, that the jurors are almost rooting for this person, to try to get their case together. But she was competent enough to stand up and make a case and cross-examine people that they thought, okay, well, I'm not giving you any points for representing yourself. Now I'm going to judge you fully as an attorney. And in that case, she was just bad enough to not do a good job. Do you follow where I'm going here? It's like she fell right into that spot where it was the worst possible result for her.
Absolutely. No, I agree completely. And that's such a great way to describe it. The sweet spot, which was probably a sweet spot for the prosecution, but not for her, right? As the defendant and pro se individual in this case. But you're absolutely right. It's, she didn't do something super wacky in court, right? Where like you said, to garner the sympathy of these jurors, to provide some latitude to her, some additional grace to her. But again, her effectiveness as, an individual representing herself, she wasn't effective. And, we saw that. We kind of had a hint of that in some of the pretrial proceedings when, for instance, she was asking for discovery before her trial and she was demanding the paperwork and the information around her extradition. And the judge was going, what does this have to do with proving up or disproving these claims? Like, why is this even an issue? And so I think there was a little bit of foreshadowing on what this is gonna look like moving forward. And sure enough, it did. So,
yeah. Last point on this, and this is what you brought up earlier, is you've got a self-defense case. So much of that is going to do with jurors understanding and appreciating what was going through the defendant's mind at the time that the killing took place. She not only did not present any witnesses herself, She didn't testify, which blew me away. I thought that's the whole reason she was representing herself, because she wanted to testify and have her moment in the spotlight. She opted not to testify herself. So instead, and even putting aside the fact that she's representing herself, you've got a self-defense case and they go into closing arguments having presented no witnesses and having the defendant not testify and just relying simply upon cross-examination. Is that a strategy that kind of ever works out, no matter who's the attorney?
I mean, not in this type of case, certainly not, and not with this type of charge. I think that, it's cross-examination can be extremely powerful, and if you have really good information that absolutely undermines the credibility of the witnesses, that, you can pull out, you can make them your witnesses on cross-examination. And the one of the nice things about cross-examination is you can ask leading questions. Well, isn't it true that? Isn't it true that? And this happened too, right? If she could have drawn out a narrative like that through cross-examination, I think maybe it could have been effective. That's a possibility. But you go in having done your homework before trial starts. You see the discovery, we've exchanged information, and then the attorney or the pro se individual has to make a judgment call. Can I get enough of the story out just on cross-examination by making these witnesses my witnesses, kind of turning them and having them read from my script, my narrative, what happened? Or can I just attack the foundation of what they're saying, attack their credibility, and then after I've weakened them there, I bring my own witnesses in and my own evidence in. And then we knock down the wall, right? And so I think she didn't do that. She didn't really effectively cross-examine. And so there wasn't like a shaken foundation there. And then she didn't put on evidence as well. So it's a really two punch there.
Yeah. Yeah, and end of the day, it doesn't sound like it was self-defense anyway. So
no.
Even in the hands of a very skilled attorney, probably would have been a difficult case. Well,
absolutely.
Like I said, she will not be sentenced until she faces yet another case, and this time for the attempted murder of Brandon Boudreaux, which we do not have a new court date for that, but we will keep our eyes on it. Finally, let's move to Jefferson County, Colorado, where an 18-year-old man is facing trial for the rock-throwing death of a woman after her vehicle was struck with a stone on a remote highway. Joseph Edward Koenig, who was a high school senior at the time of the incident, is facing charges including first-degree murder for Alexa Bartel's death. Bartel was killed after a landscaping rock smashed through her windshield, ultimately causing a fatal crash and a horrific end for the woman. Koenig was tossing the rocks with two teen friends, Nicholas Carroll Chick and Zachary Quack, who were all present when the rock was thrown that ended Bartel's life. Bartel's death was not the first incident, as the boys admitted to throwing rocks at other cars from Koenig's vehicle at targets both stationary and moving. According to Koenig's defense, the boys never seriously considered the damage they could do to the people inside the vehicles. Both Carol Chick and Quack accepted plea deals for lesser crimes for their involvement in the case in exchange for their testimony against Koenig. While Koenig has accepted some culpability in the rock-throwing incident, his defense is adamant that he should only be charged with manslaughter due to the lack of intent. They also maintain that Quack threw the fatal rock and allege the boys' inconsistent testimonies charged throughout the investigation. The changing stories will be left to the jury to decide as the testimony continues in this case, and we will keep you updated as this one proceeds. Tara, this to me, when I first read about this, it seemed like a law school thought experiment, something that we would talk about in your first year crim class, to kind of really explore the theories of intent. And this is a curious one. They've charged him with first-degree murder. Do you think this is a first-degree murder case, or does it look like something else to you?
Boy, I think this is going to be a tough one, and especially in light of the age of the perpetrators here, or the accused, I should say, in this case. I think, the state is going to have to prove, the prosecution is going to have to prove a very specific intent. And I think what the narrative, from what I can see, that's going to unfold in this case on the defense side, from what they've said too, is that, they weren't thinking that far down the line. This was hey, let's go throw rocks, at cars, and, we'll cheer when it hits and we'll boo when it doesn't. We're disappointed, without some specific intent of harming, killing, maiming, all of these other things that we're thinking about. So, it will be interesting to see how the prosecution puts this case on and pieces it together to try and meet that intent element. You're right. It seems like a law school, first year exam or second year exam question, because I would be surprised if the defense didn't put on some sort of information evidence related to the age. And I think he was 18 years old at the time. Could he have that intent? Could he have formulated that intent? We're going to have to look at all the surrounding circumstances here of this conduct, but I think it's going to be a tough slog.
Yeah, I agree. I think, to me, this looks more like second degree. First degree, showing premeditation and malice aforethought, I think, are really difficult arguments for the prosecution to make.
Yeah.
Now, this nearly is the definition, in my view, of some sort of gross, negligent disregard for the safety of others type of second degree murder. And that's exactly what we're talking about, is it comes down to intent. Can you show an intent, a premeditated, malice aforethought intent to commit murder here? Or are you showing someone who is so acting in such disregard for the life and safety of others that the natural consequences of their actions led to death, and therefore they should be held responsible for it, but not first degree, which is, depending on the jurisdiction, a huge difference. Sometimes you're talking about a life exposure or not, depending on between first and second degree murder here. So yeah, I thought that was a real stretch by the prosecution, but we'll see if there's something else they know, some conversation that took place between these teenagers that might provide some insight into what he was thinking at the time. But to that point, there's another kind of added wrinkle in all of this, in that prosecutors, in my view, need to prove who threw the rock, who threw the fatal rock. Now, you've got three young people out there who are all throwing rocks. And so now you've got to pin it on this one person. And the way they plan to do it is by, quote unquote, flipping the other two by giving them deals and having them testify. Well, isn't there a problem there that they could say, well, of course they're testifying that they didn't throw the rock because they're getting the deal. You know what I mean? And like, you could have pinned it on any one of the three if you gave them the same deal, but you just happen to pick my guy. Do you think that might be a difficult situation for the prosecution? Oh,
yeah, absolutely. You're spot on. Absolutely it would be. It's like, and as plea deals work, we don't know the reason right now why the prosecution decided to offer these plea deals to these two. Maybe they offered it to all three. These two were the quickest to respond, but it is absolutely a problem, because I think it goes back to credibility of those witnesses. If the key witnesses on your case have a plea deal on the line where they're going to get some sort of concession from the state on their own charges, or some sort of immunity or partial immunity on their own charges, do they have a motivation to testify less than truthfully or to omit certain critical facts? I think that is a really fair area for cross-examination. I think that's a fair consideration for the jury to take on. They're all under oath. They have to tell the truth. But certainly the defense can put on a defense that points out the motivation to testify in a particular way. And I would put money down that that's exactly what they're going to do here.
Yeah. No, I mean, that's the Listen, I hope the prosecution is able to pull it together because this is an awful case. No, this is the kind of stuff that makes your blood boil of somebody just driving along, minding their business, going about their day, and something horrific happens and takes their life, and it's all over people having fun. I can't stand it. But again, you want the prosecution to be able to put that case together on solid ground, and already we're starting to identify some issues here, but we will continue to watch this case as well. But in the meantime, that is our show. And Tara, I can't thank you enough for coming on this week. Tell us, where can people find out more about you? Do you have a website or social media that they can check you out?
Absolutely. Well, I am on LinkedIn. You could just type in my name, Tara, and the last is Malek. And I own a law firm that has branches in Washington and Idaho, and that is Smith and Malek is our law firm name. I'd love to connect with folks, and I'm so appreciative, Josh, that you've invited me on your wonderful show, and I look forward to continuing to follow you.
Oh, absolutely. And we hope to bug you and have you on again soon. I am your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments you would like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you again for joining us at the True Crime News Sidebar.